The reason for being called out, they were called out to a Geraldine Street address. Reason is listed as harassment. When they arrived, they took a report for harassment. They proceeded to speak to the victim, Kelsey Tinkle. She reported that she's, for a very long time now, had issues with her child's father, Stefon Scott. There are multiple cases pending. A lot of them have been dismissed involving her based on his criminal behavior against her. So what she reported when police come out there is harassment, stalking. It came in on April 13, 2025 to our office, requesting charges for stalking, malicious use of telecommunication device, and using a computer to commit a crime. When it came in, it was being reviewed for those charges. Mr. Scott was arrested. During the police contact on April 12th, Ms. Tinkle, the victim, mentioned that she had a PPO that had been issued March 25th of 2025. At this point, nobody knows that it hadn't been served. In her mind, she saw and obtained a PPO. She believed it took effect immediately, so she added that information when she spoke to officers. What then happens is almost like a parallel process. So we have charges for stalking, malicious use of telecommunications, and what was requested using a computer to commit a crime. What we also have is a PPO violation, potentially. At that point, they thought it was a PPO violation. So it was submitted essentially for both those things. The PPO violation was rightfully dismissed, not the PPO, but the violation, because he had not been served. It was discovered he wasn't served. We're not contesting that. He wasn't served until April 13th. What we have then is stalking, malicious use of telecommunications, using a computer to commit a crime. It was reviewed at like the 14th or 15th, I believe it was April 14th, for those charges. At the time, somewhat separate from the PPO violation. It was charged as aggravated stalking and malicious use of telecommunications. We didn't charge him with the request they had for using computer to commit a crime. He was arraigned on those charges on April 15th. Okay. So he was in custody a couple of days maybe before he was fully arraigned on the new charges. The aggravating factor for the stalking, while it may fail under the PPO for that instance, it certainly, we could, it would be an amendment to, he has a prior conviction, actually a few convictions for stalking. So that would be the aggravating factor that would serve the aggravating stalking charge. Moving back now, we of course have years of bond conditions that were put in place that he violated. So it would also fall under that theory for today's cases. The case was pending in front of Judge Conkey for a long time. Initially, I believe it was Mr. Bernstein on the case. Then it went to Mr. Goldstein. The report that came out of, so as this case is pending, initial contact April of 2025, Detective Sorting was asked to follow up with the victim because after the exam or during the exam, some information came out that there were a lot of other things going on, a lot of prior cases. Victim was finally cooperative, willing to testify. She was here and testified for the aggravated stalking case he initially had. What followed was end of May 28th, Detective Soren sat down with the victim and just went through essentially years of abuse that Stefon Scott had put her through. They were each outlined in a report that ended up totaling over 1,500 pages. Initially, Mr. Bernstein was on it. We made sure he got that discovery. 1,500 pages takes a long time. It would be a new case. So we gave him some time to look through that. Attorney switched to Mr. Goldstein. He needed some time to review it. And as they're reviewing it, we're also reviewing it for new charges. The decision ultimately was to absorb the aggravated stalking that stemmed from the April 12 contact into this new case with all the additional charges, because it wouldn't, quite frankly, make sense to run separate cases. Mr. Stefon Scott has been at every single court hearing. He has not objected to any of the adjournments. He's had the advice of counsel, very competent counsel along the way, several of them. At no point has there been an issue with him saying, I don't want this adjournment. No, let's go to trial right now. We were scheduled for trial. It did get postponed a few times because of the new report, the new allegations. And Mr. Goldstein and Mr. Scott were both advised along the way, very early on and repeatedly, that we have this new report, we're looking at new charges, we're working our way through the charges, and ultimately that led to the complaint we have now with 11 charges. They were both informed that the original charge was going to be dismissed, but the reason why it was going to be dismissed was because being absorbed into the new. None of this should be a surprise to Mr. Scott. And here we are now, we're ready to proceed. And what he's looking at, what's probably a big surprise to him, is that victim's here and we're ready to proceed on these charges. There's no reason that any of this should be dismissed. We're ready to go. It was done properly. He was arrested properly. And certainly there's nothing in defense's motion or in the argument today that in any way supports a dismissal of this case.
Just very brief, Judge, he wasn't arrested illegally. He was illegally arrested based on the PPO violation because the warrant for this case, the felony, wasn't issued until the 14th. So for his time to stand.
But doesn't his remedy come in the other matter?
Pardon me?
The one that's been dismissed.
Right.
That's where you're claiming the arrest.
Correct. And
so his remedy comes in that case, his ultimate remedy would be dismissal of that case, right?
Are you talking about PPO?
Well, go ahead.
No, I guess what I'm saying, Judge, is the fact that he's never been released when, again, I can't say what Mr. Goldstein did, but it just seems to me like every time he was ready to go to trial, the case got dismissed. All I'm saying is initially he's sitting in jail on violation.
Yeah, but that happened once, right?
That's correct.
You keep saying every time he's ready to go to trial, like it's repeated pattern. And I just want to make sure that it's one time it was set for trial. It gets dismissed because they have new evidence and taking that case and assuming it into this case, right?
I mean, it just burns me that they make light of the fact that he was illegally arrested. Okay, maybe it was only for a couple days, but then it was arraigned on these new charges. Then the new charges start floating along, days pass, he's not released, he's got outrageous bond amounts, and then his trial is dismissed. Again, I wasn't the attorney, maybe there was good cause for it, and you're saying, well, he didn't object. Well, that's what he's got an attorney for. And I don't want to say Mr. Goldstein screwed up, but the fact remains is he couldn't stand up and say, no, I don't want an adjournment. He's been sitting in jail for 7 years.
I get that all the time. Where people get up and say, I don't want it adjourned. Or so I don't know why Mr. Scott and somebody couldn't have.
It just from the illegal arrest, which it was, because he's never served the PPO until he got to jail, and then those charges, and the PPO gets dismissed, and then the
Okay.
gets dismissed, and now we're here.
I'm just going to break this down. At the point you say, and I don't say I agree with you, that there's this illegal arrest, charges then come out of that, right? Ultimately, as it's proceeding through, that gets dismissed.
Correct.
I'm going to stop there. That would have been the remedy, wouldn't it? I mean, up to that point, if somebody had come along and said he's been arrested illegally and we want some type of remedy for that, the ultimate remedy being dismissal of it, that happened.
It did, but the fact of it is, and again, I don't want to say it's a trick by the prosecutor, but it gets dismissed. But before he can get out of jail, the new charges are filed. And again,
but that's because they have this additional evidence, and they bring, in effect, a new case that assumes all of that in. That's where I'm here. Right? So, let me ask you this. And we won't use the word prosecutor more misconduct because I don't.
Yeah. And again, my apology.
I know.
My apology.
No, it's okay. Not misconduct, apparently trickery on their part. So explain to me what trick there is in this.
It's not a trick per se, Judge. It's just a pattern of delay. He never got out of jail since he's never gotten out of jail, and
Is there ever a motion filed for his release?
Not formally. I assume I wasn't the attorney. I would have, but it didn't happen. No.
Okay. So it seems that you, and I'm not saying it either because I wasn't there, that the complaint would be that would have never been brought before the court, right? So how's the court, if what you're saying is true, how's the court supposed to know? If nobody's bringing it before the court?
Well, let me switch back. That would just, I guess my argument would be then maybe part of the recourse would be that he has a more reasonable bond, Your Honor, on a tether, home confinement with his mother, and instead of being in jail all the time based on what has happened to him in the last 17 months. I mean, I think you and I would both agree. You were a defense attorney at one point. Seems like, and again, I understand there's delays in going to trials, but you get to it.
I was also a prosecutor in a different way. So you
get to a trial and the trial gets dismissed. And he wasn't even brought to court. All Mr. Goldstein said, hey, the trial's been dismissed. The case has been dismissed. Boom. That day.
So you're trying to tell me there was a proceeding and he's never brought to court?
No. Were you ever brought to court? You were just told that your trial was dismissed. Again, they're all little points, but all these little points just add up to the way this man's been treated regarding his Fourth Amendment rights. That's all I got to say.
I don't need a response. I've listened to it all. I don't see any trickery. I certainly don't see anything, and just only because you mentioned it, that even amounts to prosecutorial misconduct. There may be a piece that's missing, and that may be, and I'm not saying that anything was done wrong, that may be in terms of what Mr. Goldstein did at a particular point in time that we don't have here. But based upon what I see in front of me, I don't see anything that where there's been any type of mistreatment, any desire on the part of people to try to torment or violate the rights of this defendant. We're here now on the charges that were originally there, plus the additional charges based upon the new report and new evidence. And I thought we were ready to go. So in that regard, I'm just going to indicate the motion to dismiss is denied.
Judge, can I have maybe 10 minutes with my client back there? If he wants to proceed, I know what his probable answer is, but I just want to discuss a few options.
Very good. You can take it back, and so the people versus Scott.
Your Honor, the House System History.
There people on there, Stefon Scott, he's approaching the podium. State your name, Scott. Stefon Scott. Judge, today's time of day for a preliminary exam in this matter. After a long conversation with my client, discussing this matter at this time, we were going to waive the exam. My client signed the waiver. He understands he has the right to have that exam. The only right he's giving up is to hold that exam, and we want to proceed further negotiations up in circuit court.
Mr. Scott, is that all correct?
Yes, sir.
You understand that a preliminary examination is a procedure for the people would have to show by probable cause that the offenses alleged were committed in.
Yes, sir.
You understand you'll not have that hearing, although we're prepared to go today. Then you'll not have that hearing, and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their preliminary examination having been waived. Defendant is bound over circuit court on counts 1, 9, 10, and 11 following. Mr. Kellogg.
Absolutely.
I apologize, Your Honor. I believe count 10 is also a felony because it's written.
Is it?
I'll put it on the record if you want.
So it's counts 1 through 10 with 11.
Judge, we acknowledge receipt of the information waive this reading. My client would send me at this time, he's reminding me that we are seeking a speedy trial on this matter up in circuit court.
All right. Defendant ever waive all reading, standing mute. Court will enter a not guilty plea as to all 11 counts. Retrial will be set.
September 1st at 1:30 with Judge Harmon.
September 1st. September 1st, 2026. 1:30.
Today, first to send information.
Yes, ma'am. Okay. Well, all right, bond will continue.
Yeah, if that's what you want.
All right.
Thanks.
I